I rise to speak to Amendments 83, 88 and 96, which I have co-signed, but also there's some superb amendments as well. I am not a lawyer. I'm not going to apologise for that because I've had an interesting life. But I did... But I did get a lawyer to look at this for me. Not a QC, not yet, but obviously a possibility. And their thoughts were that these evidence notices treat asylum seekers like criminals. In fact, worse than criminals. They treat asylum seekers as if they were absolutely dreadful criminals. In a criminal case, late evidence might be treated as less compelling than if it had been raised earlier on, but evidence is evidence. And if evidence demonstrates a fact, then that is a fact. Facts don't care about your timescales. Rather than allowing a tribunal to determine how much weight to give the evidence, Clause 25 forces them to give minimal weight if the evidence is supposedly late. Even if the evidence were the most compelling evidence, a tribunal would be forced to give that evidence minimal weight. Now, that really can't be right. It's not justice. I cannot believe the Noble Lord Minister can stand up in a few moments, we hope in a few moments, and actually say that that would be justice. This is a totally artificial exercise. It isn't founded in justice. It's a purely political venture to make it harder and harder for people to claim asylum and easier for them to be deported. And so it has to be stopped.